In the councils of government, we must guard against the acquisition of unwarranted influence, whether sought or unsought, by the military-industrial complex.
But I do ask every publisher, every editor, and every newsman in the nation to re-examine his own standards and to recognize the nature of our country's peril. In time of war, the government and the press have customarily joined in an effort based largely on self-discipline to prevent unauthorized disclosures to the enemy. In times of clear and present danger, the courts have held that even the privileged rights of the First Amendment must yield to the public's need for national security. Today, no war has been declared, and however fierce the struggle may be, it may never be declared in the traditional fashion. Our way of life is under attack. Those who make themselves our enemy are advancing around the globe. The survival of our friends is in danger, and yet no war has been declared. No borders have been crossed by marching troops. No missiles have been fired. If the press is awaiting a declaration of war before it imposes the self-discipline of combat conditions, then I can only say that no war ever posed a greater threat to our security. If you are awaiting a finding of clear and present danger, then I can only say that the danger has never been more clear, and its presence has never been more imminent.
It's time to recognize that we've come to a turning point. We're threatened with an economic calamity of tremendous proportions, and the old business-as-usual treatment can't save us. Together, we must chart a different course. We must increase productivity. That means making it possible for industry to modernize and make use of the technology which we ourselves invented. That means putting Americans back to work, and that means, above all, bringing government spending back within government revenues, which is the only way, together with increased productivity, that we can reduce and, yes, eliminate inflation.
The only thing that can stop this corrupt machine is you. The only force strong enough to save our country is us. The only people brave enough to vote out this corrupt establishment is you, the American people. I'm doing this for the people and for the movement, and we will take back this country for you, and we will make America great again.
Hello, welcome to Inform America. I'm your host, Rich Merritt. Co-host today is Wylene Poliquin. Welcome, Wylene.
Thank you, Richie.
I want to mention first and foremost, as I always do, the nationallibertyalliance.org. Please check them out. I happen to think that they're doing some great things. If this country happens to unfold in the right direction, they're on top of things and ready to pounce on what should be pounced on. Anyway, check them out. And speaking of that, for an educational tool for your children, you can't beat what they're showing on their webpage. Cannot beat it. I don't care who you are. You can't beat it. Unless you want to go all over the place to find out the information they have. Check out their website, though. Secondarily, I talk about the Boston Broadside because since I've found that particular paper, I found them to be truthful and honest. That's the only thing I look for in the news. Tell me what's happening. I'm a big boy. I'll decide what it is I'm going to do, if anything. But I don't need to be lied to like the lamestream media. Check out the Boston Broadside, the People's paper. I think you'll like it. Also, I got to mention it. I wrote a book several years ago, as you can see here, Stand Your Ground. And I put it on the back burner because I thought what I was doing here was more important, and I still think that, I guess. But I wanted to put the book out before I croak and not get a chance to put it out there. So if you have a chance, check it out. I believe the flyer will be put up at the end of the show with the, the website, so you can go to it. And our show today is going to be on the family court, one of my favorite topics. So with that, we'll show a brief video and we'll be back to talk about it. Thank you.
Judges
Judges in Georgia decide the fate of thousands of children who are caught in divorce. Now, the tough decisions are often influenced by court-appointed advocates, but critics say some of these advocates are poorly trained and potentially
Not at all,
biased.
Stephanie.
Wow.
So bear with me. This gets a little complicated. The story, the legal term for these advocates is guardian ad litem. They are attorneys sworn to look out for the best interest of children. Many of them do that, but some parents and child psychologists say some don't.
It's like being raped of your children.
Alex Higdon
The mental anguish for both my children and I has been huge.
and Gracie Ortiz-Terrett have never met, but both say they were railroaded in court by powerful attorneys charged with protecting their children.
No evidence was presented to change custody. There was no reason for them to change custody. There was nothing presented that would even carry any weight to change the custody. As a parent, the only thing you want to do is protect your children. And this legal system now has put me in a place where I have no power. They put the power in the hands of the psychologist, the kid's attorney, the evaluator, and they're essentially trying to take me completely out of my children's lives.
I'm the one who has lost custody of my children.
In an interview earlier this year, Terrett says Raina Nadler and Jeannie Kuttner were far from objective in their investigation. In court documents, her attorney alleges the women improperly communicated with the judge, dictated changes in her custody, and even yelled and shouted at and tried to influence Terrett's witnesses. And there's more.
They refused to meet with me. They refused to obtain any information from me. For a period of 90 days, they continued to work with the opposing party. And guardian ad litem just simply cannot do that.
We tried to talk with the Guardians after they didn't reply to 3 requests for an interview.
And I'm Jeff Cherica with CBS Atlanta News. Can you please?
One answered the door, but not our tough questions.
The opposing party recommended a guardian ad litem.
Higdon, a former Atlanta Falcon, tells a similar story.
Don Smith?
He says guardian ad litem Don Smith, seen here in a YouTube video, recommended changing his son's school and his custody before evaluating him. And Higdon says this 2010 email shows Smith lied to get the job. It appears to show Smith claiming she has no connection to or opinion on a group that opposes the autism treatments Higdon's sons were receiving.
Well, we come to find out she was actually on the board of that institution in 2004 and 5. She had a personal agenda that she was going to fulfill, and that personal agenda not only included her agenda of how she believed about autism treatment, but it included also about retaliating against me for giving her pushback.
I don't think there's any agency in the world that should operate without oversight, and especially something as important as family court. It seemed to me, based on actually inappropriate conversations between the judge and the director, that they tended to disbelieve allegations of domestic violence. I remember the judge would call us into these morning staff meetings that actually were not permissible under the law. But she would call us into chambers before we heard any cases that day, and we were having ex parte communication about how the court should handle the case. And I remember a conversation between the judge and the Family Court Services director saying, "Oh, Mrs. So-and-so is back. I can't believe it." And the judge said, "She's so histrionic. I think she's completely exaggerating her domestic violence claims." And the director said, "I agree." And they said, "Yes, we need to make sure that these kids have more time with their father." And unfortunately, that was not an isolated incident. There were conversations that I heard repeatedly during the last year of my employment that led me to believe that domestic violence victims were looked at as whiners, as weak people who needed to learn to get along with their perpetrator for the sake of their children.
Many of them don't know what they're saying. And, and it runs up the bill. There's no accountability. They're inherently biased.
Family therapist and expert witness Dr. Monty Weinstein says he's seen guardians often push to limit one parent's custodial time, which he says isn't healthy. He says guardians are highly paid but poorly trained in child development, biased, and potentially influenced.
The guardian ad litems would go with the law firms that give them, in many cases, the most business. So if the law firm is advocating, let's take this mother or father out of the picture, unfortunately, many times they'll find a rationale to talk to the judge.
Since there's no agency that oversees or licenses guardians, it's hard to know how big the problem is. The State Bar Association tells me it doesn't track how many, if any, guardians it has disciplined.
The judge and the mediators would tell parents terrible things would happen to their children if they weren't able to reach an agreement on behalf of their children. The judge and her predecessors held up a picture of a young man and would yell at parents in the courtroom, if you two can't learn to get along, your kids will end up pregnant, on drugs, or like this young man who committed suicide on the day that his parents went to court and failed.
If I were the devil, I would attack the foundation of American society, the family unit. And I keep thinking I'm through with this series, and the Lord keeps showing me more and more things, and I keep feeling that needs to be preached. So I was planning on this being the last, but next week we'll conclude, I think.
I was so distraught at what I was being asked to do because I felt like I was in a position where I had to either protect my job and myself and my family and our income, or to protect the families I was working with. And it's put me through hell. I went out on stress leave. I went through a full arbitration process where the arbitrator found in my favor, but not before they had fired me from my job. And it's outrageous to me that nobody is providing oversight of the court. Aside from the court, there is a conflict of interest there.
If I were the devil, the first thing I would do in attacking the family is I would convince people that marriage is just not important. My first deception would be to convince people that it's just a whole legal entanglement that's not necessary. It causes a lot of headaches. And so I would encourage more and more people to simply live together and forego the legalities, the formalities, and the commitment of marriage altogether.
Do you have any opinion as to whether or not there should be more oversight of guardians ad litem?
I think we have the appropriate oversight.
The state's child advocate, Tanya Boga, says she thinks guardians are largely honest and ethical and believes the court system weeds out the bad ones.
The judge can remove this guardian ad litem if evidence is brought before the court to share that this person is not engaging in their duties properly.
But Higdon and Terrett say the judge shrugged off their concerns, putting their kids at risk.
The children are not getting treatment for the underlying medical challenges.
And he just says he hates his life. And I can't tell you how many times I've heard that from both children because they don't get to see me.
Now, I've spoken to one man who says the court ordered him to pay the guardian $60,000. There is no proof that any of the guardians in this story were influenced by money. The point is, there just isn't an agency that can determine when it does happen. Dawn Smith didn't reply to any of my 4 requests for an interview.
Jeff, do these parents have any recourse at all?
Not really. Once the judge rules, it's really hard to change anything. Now, Alex Higdon is filing a federal lawsuit against both the judge and the guardian. And in Terrett's case, which is very rare, the original judge stepped down, a new judge took over and kicked both over.
The incidence of fatherless homes is reaching epidemic proportions. A third of American children, statistics say, live in homes without their biological father. In the past 50 years, the percentage of children who live with 2 married parents has dropped 22 points. During that same time, the number of babies born to unwed mothers jumped from 5% to 36% of births today. The growing trend of absent fathers has grave implications for our society, researchers say today. Now, I'm not trying to beat up on single parents. Believe me, I want you to hang on and hear what I'm going to say in just a moment. But let me describe the urgency of this situation today. Researchers give us an outlook on the impact that fatherlessness is having on our society. 90% of homeless and runaway children are from fatherless homes. 85% of the children with behavioral disorders come from fatherless homes. 71% of high school dropouts come from homes where the father's not present. 85% of the youth in our prisons are in homes where the father's not present. 75% of adolescents in chemical abuse centers come from homes where the father...
All right, so that was basically about the family court system in America, New Hampshire. A couple of points I wanted to say, and then we were going to speak about the law. The points that I wanted to make, they're talking about the way the system is. What we are going to talk about is what the law says pertaining to that and how the system now is perverted. They're talking about these guardian ad litems. I can tell you that I read both the state and federal constitutions multiple times, and that word doesn't appear in here. Neither does lawyer. We never turned our legal system over to lawyers or the bar. They stole it from us. I want to be very clear about that. They stole it from us. When this was ratified in 1783 in the state of New Hampshire, the Constitution, we became the sovereign class of people. And it's common law, the land jurisdiction. It's been stolen from us. That's called the court of record. They stole it from us. We'll get into that a little bit later. But right now, Wylene's going to read Article 5, and we're going to make a few points on Article 5 to show, at least in my mind, well, we'll clear it up. Wylene, if you want to pick up on Article 5, please.
Sure thing. Article 5. Power to make laws, elect officers, define their powers and duties, impose fines, and assess taxes, prohibited from authorizing towns to aid certain corporations. And farther, full power and authority are hereby given and granted to the said general court from time to make, ordain, and establish all manner of wholesome and reasonable orders, laws, statutes, ordinances, directions, and instructions, either with penalties or without, so as the same be not repugnant or contrary to this Constitution, as they may judge for the benefit and welfare of this state.
Now, by state, we live in the state, so it means people also, right? Because, oh, by the way, I meant to tell you, just before we came in on Elm Street, I don't know if you saw that, the bus that was out there?
Yeah.
You wouldn't believe, the line was 2 blocks of states waiting to get into that bus. On two blocks.
Well, Richie.
What?
State and people, they're not the same thing.
Are you sure? It says state there, and people think it means them. It's got to be the same thing.
No, state and people are 2 different things. People is a group of individuals. Individuals meaning one person.
Yeah, but, well, let me just correct you here for a second, because that says that the legislature, the general court, will make laws, rules, statutes, orders, directions, and instructions for the state. So that means the people, right?
Well, yeah, but the state is what consists of people. But you want me to read the definition of what a state is?
Sure, maybe that will clear it up.
Okay. State is a noun, and it's political organization of a country, supreme civil power, government. Says from special use of state, this sense grew out of the meaning, condition of a country with regard to government.
One thing I want to point out, because a lot of people don't know this, is New Hampshire is a country. Just like Massachusetts, Texas, California, there's 50 countries in the United States of America. State is a country. And the reason that I did that, and me and Wylene played a little bit back and forth, is it says the the general court can make laws, ordinances, statutes for the state, for the government, not the people. It doesn't say the people, doesn't mean the people. Those 2 words don't sound the same. They're not spelled the same, and they have different meanings. And by the way, if you've caught what Wylene, when she read the definition, the word people didn't appear in the definition of the word state. It talked about the government of a country. point I'm raising here, and I hope it's a really valid one, because people have to realize this. I talk to legislatures, and they agree with me, and 5 minutes later, they go back to talking about statutes. Oh, yeah, and one of them was talking about a septic system and said, yeah, the statute says this. I'm going, what are you talking about? Now, I understand, for those of you who might know me, I understand that the Constitution has been stolen, both state and federal. It doesn't exist in America. We're a corporatocracy, or whatever the hell you want to call it. But the point still has to be made. This talks about the general court making statutes for the state. Statutes don't apply to you. If you want them to apply to you, that's great. But the thing I'm trying to point out here is that you are abiding by the statutes that don't apply to you. You're consenting to them. We're going to get into that in a minute. But first, I want to go into Article 4, if you would, Wylene, please.
Absolutely. Article 4, power of general court to establish courts. The general court, except as otherwise provided by Article 72A of Part 2.
Let me just stop you there for a minute,
Sure.
please. I did want to say that Article 72A, which I've researched extensively, is unconstitutional. That's when the legislature proposed general jurisdiction. And when they proposed it, they put it in under general jurisdiction, which I guess you couldn't, maybe you can argue strongly for it, maybe you can't. But what they did also and didn't tell anybody was they stole from us the land jurisdiction, which is common law or courts of record. They took it from us. Totally unconstitutional. No authority whatsoever, but they did it. I'm sorry, go ahead.
No, you're fine. You want me to just start over?
After 72A, yeah.
Oh, okay. Shall forever have full power and authority to erect and constitute
Judictories. I'll jump in because I wanted to
Judictories.
stop you anyway. Yeah, full power, and you have to pay attention to the words, full power and authority to erect and constitute judictories. To erect and constitute is to build or stand up, not to create. If it wanted to use the word create, it would have said create. Erect and constitute, to build or stand up, or make stand, however you want to look at it. You can look these definitions up yourself. And a judictory, which I found to be a very strange word when I ran across it myself, is an institution of justice. An institution of justice is either a land jurisdiction, a court of record, as it mentions in a second, equity jurisdiction or an equity court, or the jurisdiction of the sea, which is admiralty maritime. Admiralty being the military and maritime being private enterprise or private commerce. Sorry, searching for the words. Go ahead.
And ironically, what you just said, and courts of record, which...
Yeah, I just wanted to stop you on a court of record
Yeah,
because
'cause
you
we
had
need-
asked me on the phone. Yeah.
Exactly. What exactly is a court of record? Because I didn't even know that that existed, because apparently they don't.
Well, I hope a lot
they're
of people
supposed
watch
to.
this. And here's the reason why. I've seen people in court say, is this a court of record? And the judge say, yeah, we're recording this. The definition of a court of record, and you can look this up in Black's Law, all right? I'm not making it up. There's 4 criteria that have to be met. The first one is it operates in the course of the common law, okay? And if it doesn't operate in the course of the common law, it's not a court of record. It's real simple. The second one is has its own seal, all right, like a notary seal, that type of a seal. The third one is the magistrate is separate from the tribunal. What it means is the judge or the magistrate, they call him, is separate from the jury. Okay, the jury isn't part of the court system; it's part of the people system, the sovereign class of people that run this nation. And when they say in a court of law, not guilty, nobody can overturn that. Not the Supreme Court can overturn it. That's a fact. Now, if someone's rights have been violated or some stupid technicality, but they can't overturn it on the basis of the jury ruling on it, the fact, the truth of law. If I violate the law and I'm in front of a jury and the jury says, well, that law is unjust, they can rule it unjust and say he's innocent. That's a stupid law. And there's nothing anyone can do. That's the power of nullification that the jury has that we don't know about today because we're ignorant. We are the ultimate authority in law. We've ratified the state constitution in 1783, making this a common law document. We are the sovereign class of people in the state, and that goes for the other states around the country, okay? Our public servants are the government. They're supposed to be working for us. Today, they're our masters because we've allowed it to happen. Our ignorance has allowed it to happen. If we don't understand this, and that's what we're trying to point out here, by the way, is the ignorance of all of us. If we don't admit to us being ignorant and saying, hey, we got to do something about this, our ignorance is taking us down. So find out what you're ignorant about and do something about it. If you don't exercise your rights, you don't have them. Just like if you don't exercise your body turns to whatever. It's not a good machine, let's put it that way. If you exercise your body, you stay in good shape, right? Well, it's the same thing with your mind. Keep it sharp, understand what the law says, and who you are in that thing. You're not some type of well, we are slaves now. I can't really say that. You're not supposed to be.
Right.
Anyway, if we could get into Article 1. Or did you finish Article 4?
Well,
I'm sorry.
No, it says, or other courts to be holden in the name of the state, which we
Okay.
already discussed what the state is, right?
Yes. It's
Okay.
not beholden to the people. It's beholden
Right.
to the state, the government. Yeah, if you want to go to 1 then.
Okay, Article 1. Equality of men, origin and object of government. All men are born equally free and independent. Therefore, all government of right originates from the people.
All right, that's key. All government of right originates from the people. Now, that means this book, the federal constitution too, but the state constitution, word for word as it's written, that's government of right. The people authorized it. But anything that's repugnant, contrary, or in opposition to this document, hey, that's not government of right. Okay? Doesn't mean anything. It's null and void. It means nothing. But if you don't know what is repugnant and you consent to it, what are you doing? Ignorance. By the way, I don't want anybody to get the wrong idea here. I've been ignorant for 50 years. The biggest ignoramus out there. But I'm trying to change my attitude and my understanding of what's going on, but also help other people.
What people need to understand is that being ignorant isn't really, it's not an insult. It just means that you're not knowledgeable.
It's not a permanent condition
what
either.
This is.
Right.
You know what I mean? They're not
Right.
knowledgeable that we've had our rights taken from us. That's all you're saying. You're not knowledgeable.
I like to use the word ignorant because I think it sharpens people up a little bit. It's almost like a slap in the face, I'll admit it.
Yeah.
But ignorance is simply you don't know, you don't understand, or
Right.
you're not familiar with.
And that's
It
all
doesn't
you're
mean
saying to
stupid.
them. You're not telling them you're stupid. You're just saying you don't know what's going on here.
No, well, if I was
So-
going to call you stupid, you people listening, I'd be talking in the mirror to myself because I was for 50 years.
Exactly, we
Ignorance
all
is a
have.
condition you can overcome.
Right, exactly. But originates from the people, is founded in consent, and
Okay.
instituted for the general good.
That's about the most important 4 words in that whole
Is
Article 1.
founded in consent.
Is founded in consent. I said it several times during this thing. If you consent to what's going on because you don't know better, you are consenting to it through your ignorance. Not voluntarily, you don't know any better. But ignorance is no excuse of the law. Any judge will tell you that. Even the many judges that are out there dealing in corruption. So when they go on trial in a military court in the near future, they can't plead ignorance of the law. So when the jury says, hey, hang him, hang him, too bad. I have no sympathy for you. You want to help in aiding and destroying this country? That's what you deserve. That's up to a jury, not me. But consenting to something that you don't have to, and it says it right here in Article 1, that's another key point. Article 1, not Article 27 in the Bill of Rights. Article 1 is founded in consent.
Gotta wrap it up.
How much time do we have?
I think we're past it.
Oh, if we're past the time, I apologize. Please subscribe to this channel. Thank you for watching, and we'll catch you next week. I hope you learned something. Double check what I have to say, though. Thank you.